Good morning. Today I would like to discuss with you about dying declaration, which is dealt under Section 32 of Indian Evidence Act. For that, there is a judgment, AR 2023 Supreme Court 94, AR 2023 Supreme Court 94, Rajaram versus State of Madhya Pradesh. Actually, there were two dying declarations by the deceased, one by Naib Dasildar, other one by recorded by the police. So the reliability of a dying declaration depend upon surrounding circumstances and credibility which the court attached to it. Here, since there was no proper recording dying declaration, initially there were several accused, and Santa Boy, the main accused, was convicted under Section 302. And thereafter, the first dying declaration speaks about Santa Boy's involvement. But second dying declaration imputing further allegations of demanding dowry and all those, since that was disbelieved, the Supreme Court in Rajaram versus State of Madhya Pradesh acquitted the other accused, including husband. Now, question arises, why I am referring this judgment apart from the ratio. See, normally whenever the dying declaration means Article 32, but practically Article 32 not only for dying declaration. Therefore, I would like to take your attention for the young lawyers to the Section 32 of evidence. Number one, the title of this Section 32 was Cases in which statement of relevant fact by person who is dead or cannot be found is relevant. So somebody who could not be found or dead is evidence, is statement, earlier statement, prior to his death or prior to his disappearance is relevant, means it is admissible. So, see, statements written or verbal or relevant facts made by a person who is dead, who cannot be found, who has become incapable of giving evidence, or whose utterance cannot be procured without an amount of delay or expense under which. So this main section deals with statement of dead person and the person who could not be procured. It is not dying declaration. Kindly understand that Section 32 Indian Evidence Act, the major provision is not dying declaration. Subsequently, they say the themselves relevant facts in the following cases. Therefore, dead or not found persons evidence, the earlier statement is categorized under Section 30. Number one is it relates to cause of death, that is dying declaration. When the statement is made by a person as to the cause of his death, any of the circumstances of the transaction which resulted his death, in cases which the cause of that person's death comes into question. So, dying declaration, number one category. Such statements are relevant whether the person who made them was or was not at the time of they were made under expectation of death, and whatever may be the nature of proceeding which the cause of death comes into question. So then that is that. Then other one. First thing is dying declaration. Second thing is made in the course of business. When the statement was made by suspect in the ordinary course of business, inspectors, doctors, government officials. When it consists of any entry or memorandum made by him in books kept in ordinary course of business, or in discharge of professional duty, or upon acknowledgement written or signed by him of receipt of money, goods, security, so many things. This is for bank officials, government officials, police officials, doctors indulging in public duty. There should be some entry. Then third one is against interest of maker. when statement is against the pecuniary proprietary interest of the person making it, or when, if true, it would expose him or would have exposed him criminal prosecution or to suit for damages. This is against the person who makes statement, if suppose incriminate himself. Then section 4 gives opinion as to public right or customs or matter of general interest. So these all are expert evidence and elders evidence. Then this all things regarding existence of public right, custom or matter of public or general interest. That statement made by the person who dead or not found is relevant. Then relates to existence of relationship by blood, marriage or adoption between the persons, as to whose relationship by blood, marriage or adoption the person making statement had special mean of knowledge, and when the statement was made before the question dispute was raised. So subsequently if you give statement, that is inadmissible. Prior to the dispute raised, if somebody has given some information or statement who is not found or dead regarding relationship by blood, marriage or adoption is admissible. See now how many categories of dying dead man's statement, or the person who is not available statement. Number 1, dying declaration. Number 2, ordinary course of business. Number 3 is against the maker. Then the public right. Then relationship. Then who made will or deed relating to family affairs. This is also most important. Here the question arises between the person deceased made by will relating to affairs of the family. Family portrait, so many things are there. Then this is whether that 6 will be available to the persons not found means you can try to execute the will if the person is not available for continuous period of 7 years unheard. Then you can apply the section 32 class 6. Then any statement containing any deed, will or other document related to any such transaction mentioned in the section 13 class A. 13 class A Evidence Act deals with the different things that we will come to later. Then or is made by several persons and expresses feeling relevant to matter in question. When the statement was made by a number of persons and expressed feelings or impressed on their part relevant to the matter in question. Suppose some feelings regarding some which had happened, that we suppose that there were several persons made expression and they were not available, then that may be relevant in question. So number 1, section 32 Evidence Act is not particularly for dying declaration. It is for the statement of the dead person or the person who is not easily traceable or not found. But there are 7 categories of such statements admissible in law. Number 1, dying declaration. Other things I have already read. So this way section 32 should be understood. If they say dying declaration, only section 32 Evidence Act, you can tick that answer. Suppose dying declaration, they say article section 32 Evidence Act 1 or 2, whatever it may be, you have to go through the Indian Evidence Act and peruse it and see whether the statement given in the objective question paper is befitting either 1, 2, 3, 4, 5 to up to 8 or not. This is where you should answer the questions. I hope you understand, because I want to stress again and again that section 32 is not only 160 Indian Evidence Act is not for dying declaration alone. There are 8 categories of statement which are relevant, admissible in evidence if that the statement made by the person is dead or not found, are not easily procurable without long consumption of time. This is the way you have to understand best research.